class of OBC A or OBC B. Your Lordship pointed out in your Lordship's judgment that this is to be a dynamic data analysis based on quantifiable and identifiable data. As a result of this dynamic data analysis, some classes which were placed in OBC A are now in B. Some classes which were placed in OBC B are in A. Malad, I am not here to this is not Malad a religion-centric exercise.
We have struck down the very basis of A and B.
Yes.
How you are dealing?
No, your Lordship has your Lordship has not done. No, your Lordship was pleased to hold that it has to be done. Malad, the process was illegal as held by your Lordship. Your Lordship has not held. Subject to your Lordship's kind consideration, this sub-categorization is not permissible. Subject to correction, my lord, I will stand corrected, my lord. I will stand corrected. My lord, whatever I have read, your Lordships have held that it was all state in the earlier round. Because state appointed the surveyor, state made this recommendation. Yes. So, my lord, so consultation, that process of consultation has been concluded in some cases. In 71 cases, 76 cases, this process is over. I believe notifications have been issued by the state and placed before the state legislature. 41 cases are still pending, are still undergoing, which also has these, my lord, these classes. Then, my lord, another set of classes are being considered pursuant to your Lordship's direction. We have tried to follow to a T whatever your Lordship had directed. My lord, these allegations are vague and too wide and too reckless. Too wide and too reckless to be made in a PIL just for the purpose of stalling a process.
We are not.
And kindly hear us. My lord, we are not shy of hearing. Kindly allow us to use an affidavit within 7 days. We'll file affidavit. We'll come back to your Lordship and get the matter heard.
We are only saying,
yes,
we have no powers, or we should not normally exercise powers on a legislative process,
yes,
and we don't do it.
Yes.
Because the theory of separation of powers is very important.
Right.
At the end of the day, you have placed a certain data before the legislature for its consideration.
Correct, my lord. Correct.
Now, the legislature may accept, may reject, may modify or do whatever it deems, or remand matter back to you. That is the wisdom of the legislature.
That's the legislative affirmation.
That is the wisdom of the legislature.
Right.
Now, at this stage, there is good, bad, indifferent, an application from their side, questioning some issues or whatever, bald or otherwise.
Then, my lord,
there is no response as yet to your affidavit in opposition.
Absolutely.
Now, unless the pleadings are complete.
Yes, ma'am. Kindly do that. Kindly give us a short date.
Time we suppose tomorrow.
Yes.
In the process of these 7-8 days, unlikely 7 days or another 3 days, 4 days.
I cannot answer that, man. I cannot answer that.
It is unlikely that the legislature will just pass everything and implement the data. Is that what
the legislature has passed? It has been passed.
Placed before the legislature, and this has been passed. These are the documents.
Advertisement has also been issued. Advertisement issued. Everything has been started.
Even pending
advertisement has also been issued.
But it has been laid before the legislature, and legislature has approved that. But that is the process which has been laid down by the court, and which is.
Was it placed in the form of a bill, or was it placed in
No,
the form
it has
of
been.
an amendment?
It has been
to the act.
It has been placed or laid before the legislature.
It has been laid
before in the form of a report as per the statute.
No,
as per section
93 or 2012.
93, of course.
There is no action under section.
Of course, 1993.
So as of now, there is no action on the 2012 Act, which is the guiding legislation.
Well, probably they are not following that act.
No. Not probably. Let my learned friends say that it has not been followed, or the proper law has not been followed. Why probably?
Why they are not to have a 20